Hot.
Okay, yeah, you ready?
Alaikum
Assalam
wa
wa
rahmatullah.
Yeah, he said it'll be in about 5 minutes.
Alhamdulillah. Wassalatu wassalamu rasulillah. Wa ala alihi wa ashabihi wa man sara sabilihi ila yawmiddin. Amma ba'd. So we continue discussing the book Al-Mulaqis Al-Fiqhi by Shaykh Salih Fawzan, Hafidullah Ta'ala. And still discussing matters relating to Al-Mawarith, matter relates to Farahid, inheritance. So we pick up from where we had stopped in the last lesson, where we start discussing certain cases that people may not be, or people may be missing in act, or people cannot be found, they're missing. And the other case that was mentioned is regarding Alhamdulillah, regarding a lady who's pregnant. What's the ruling regarding that, regarding inheritance, that situation? And the second situation regarding the person who's said to be mafqood, the one who's missing. So pick up from what he discussed regarding other cases that are also taken into consideration regarding ahkam al-mawarith. Aywa.
Bismillah wa salatu wa salamu ala rasulillah wa ala ma'allif rahimahum hafidhahullah, chapter 20, page 323. Inheritance of the drowned and those killed under collapsed buildings. The issue of mass deaths in which many people die and some of them are legal heirs of others is a problematic issue that causes great confusion. This is because it is difficult to realize who has died first to be considered an inheritor and who has died later and is considered an heir. Nowadays, mass deaths frequently happen as a result of road accidents such as a car and train accidents and plane crashes. Mass deaths can also be a result of building collapse, accidental fire, drowning and bombardment. With this in mind, the issues involved in the inheritance of those deceased people who legally inherit from one another are summarized into 5 cases.
So alhamdulillah, Sayyid Shaykh Hafidullah discussed concerning another of those masail that relates to al-mirat, and this case regarding if people, a group of people have died. They're mentioning regarding that the masala regarding وَيَا مَسَلَةً الْمَوْتِ جَمَاعِي. So if a group of people have died all together, then what's the case regarding if some of those people are related regarding who's out to decide regarding the rights of inheritance? Regarding those cases, we might find that amongst those that are deceased, that they inherit from each other. So what's the ruling regarding such cases where multiple people, or I said mass group of people, are killed close to the same time? What's the ruling that pertains to this regarding inheritance? So it could be concerned is mass killing. It could be, as the Shaykh mentioned, and others have mentioned regarding, it could be a case concerning that a car accident or a bus accident where many people may have passed away in that accident. Also, it could be by way of a train crash. It could be by way of a plane crashing and the likes. Or it could be by way of a group of people drowning. So people on a boat or a ship, and they all drowned from that situation, or by way of fire. Or it could be by way of people being killed altogether. So those are the cases that may occur where many people are killed at the same time. What's the ahkam regarding inheritance in relation to those who are related? Aywa.
قال مؤلف حفظه الله, when all the deceased persons are known to have died at the same time. In this case, scholars unanimously maintain that there is no inheritance, as inheritance is based upon verifying that the heirs or the heirs is alive after the death of the inherited person, which is not available in such a case. When some of them are still unknown,
That's the second. So that's the first case?
That's the first case.
Hey, so they mentioned the first case, so you mentioned there's 5 cases relating to this, where also the issue with these cases regarding that being able to distinguish who died first. So to distinguish who dies first, so one can, so that's also the thing that one has to take into consideration in these type of mass killing or deaths, that knowing who are those who died first, and regarding that those who died after, as how that might impact on them inheriting from each other. Anyone?
No.
So it's mentioned the first case regarding that, it is لا يعلم أن الجماع مات أفرادهم جميعا في هان واحد. So everyone at the same time, in that case, in ijma, then there's no inheritance between themselves.
قال المؤلف حفظه الله, when some of them are still known to have died before some others. In such a case, scholars unanimously view that those earlier, since it is verified that the heirs has temporarily survived the inherited person. When some of them are known to have died before some others without determining who have died first.
That's the third case.
Yeah.
So they mentioned, so the first two cases he mentioned in the ijma between the ulama, that in those cases, the first case where one knows regarding that all of them died at the same time. So no one inherited over the other, as all died at the same time, so that is somewhat known. The second time, أن يعلم تأخر موت أحدهم, that if one knows regarding one know who dies first and who died after. So in that case also, that there's inheritance between them. But so even though the person, so in these cases where you find that a person have died, and you are related to that person, so you died soon after, but the fact that you still inherit from them. So a person might, you have, for example, as an example, the father died an hour ago. Now, he had an accident occurred in the vehicle. You had the father, you had the mother, you had some of the children. So the father, he died. Now, he died on the spot. But then, but it was known that he died first. Then, for example, the wife, she died hours later. Then she's deserving to inherit from him. So even though she died, what of her portion from him to be passed on to her, even though she died, and what of her be passed on to those who come after her. So in that scenario, so that's the scenario that, so in those cases, it still matters, even though knowing who died first and who died after. Clear? There you are. So in a case, for example, the husband and wife, they died in an accident. But it was known that the one died before the other. So the other one inherit, even though they died a couple hours after, but meaning that their inheritance may now, for example, the wife was to die, or the wife, she's wealthy. So the wife, she's wealthy, and the husband miskeen. So an accident occurred when both were together. She died first. So her inheritance, he inherit from her. But then he died later. His family members now inherit from and they are fuqara. So for them, mashallah, that they gain something. They gain something. So those are the first two cases. Knowing that all died at the same time, no inheritance. If you know, if you are aware of those who died first, then there's inheritance between the ones who died after. That's the first two cases. حالة الثالث,
when some of them are known to have died before some others, yet that is forgotten.
That's the fourth.
That's third.
That's the third. Okay.
Fourth.
That's the fourth in mine.
Yeah, it's the fourth in yours, but the third in the second subcategory.
Okay.
Yeah. Because one category.
So I put them in two categories.
Yeah.
Okay. Now in my book they have it in 5 categories.
Okay.
In mine they have it in 5 categories. They discuss. Okay, تفضل.
Fourth one, when the sequence of their deaths is unverified and it is not recognized if they have all died at the same time or at different times.
That
was the last point.
So in my book they have it in 4 categories. There are 5 scenarios. But in your book there's
4.
There's 5.
But they put 2 together.
Yeah, so they put them in 2 separate categories. So one was
The ones that are agreed upon.
No one inherits. That's just one category.
Okay, they put all those. Okay, they put those ones that are agreed upon as one category. The others separate. That is a khilaf. Okay, ماشي. أيوة.
In these last three cases, there is a great room for probability, ijtihad, legal reason and discretion, and speculation amongst scholars. May Allah have mercy on them, who entertain two different opinions. The first opinion entails that there is no inheritance between those deceased people in all these three cases. This view is supported by the opinion of a group of the Prophet's companions, including Abu Bakr as-Siddiq, Zayd ibn Thabit, and Abdullah ibn Abbas. May Allah be pleased with them all. The three Imams, Abu Hanifa, Malik, and Ash-Shafi'i, may Allah have mercy on them, said the same, and it is one of the opinions adopted in the school of Imam Ahmad. This is based on the fact that one of the conditions to inherit is the certainty that the heir is alive after the death of the inherited person, which is not only unfulfilled here, but also doubted. And the rule of thumb is that there is no inheritance with doubt. Moreover, those who died in the battles of Yamama, Siffin, and Al-Harar did not inherit from one another.
So that's concerning. So regarding the three last cases that are mentioned, that there's some doubt as to Yalam, that they mentioned these three cases that they know who died first, but there's some variables that are still not known. So even though some things are known, but also there's some things that are not known in the latter three cases that he mentioned. So based upon this, that the ulama have disagreed regarding in these three last cases. The first two cases, there's ijma that in one case they inherit, and the second case they do not inherit. But in these three other last cases that is mentioned, that there's some doubt regarding certain things. So certain things that are unknown. So they mention, as I know with this, that the ulama, that they have a khilaf, where that it is of those, the first view of the ulama is that in this case, Adam al-Ma'a tawaris, that tawarus, that they do not inherit between themselves. So in these first three last cases, there's no inheritance that take place. And he mentioned that of those who of that group, he mentioned amongst the Sahaba, Abu Bakr as-Siddiq, Zayd ibn Thabit, Abdullah ibn Abbas, and others. And amongst the A'immat al-Araba, that he mentioned Abu Hanifa, Malik, wa Shafi. And also he mentioned Takhrij fi Madhab Ahmed. Takhrij Madhab Ahmed is one of the terminology used by the ulama of the mustalahat of the Hanabila. But overall, that's the view that is for that none of those people in those three cases, no inheritance take place between them. Aywa.
The second opinion entails that each of them inherits from the other, following the opinion of a group of the companions, may Allah be pleased with them, including Omar ibn Khattab and Ali ibn Abi Talib, may Allah be pleased with them, which is the opinion acted upon in the Hanbali school. The underlying assumption behind this view is that each one of them has certainly been alive and must have lasted until after the death of the other. To illustrate, when Omar, may Allah be pleased with him, was informed of the plague that afflicted Asham and that whole families died as a result, he ordered that the estates of the dead persons would be estimated according to the shares they were to receive from one another, and then the living heirs would inherit from the dead persons. It is stipulated that the living heirs of the dead persons do not differ with regard to the precedence of one to another in the order of death. When every heir claims that his inherited person has died later with no evidence, then they have to take oaths and no inheritance is to take place.
Yes, that's the second view that is clarifying, the second view that is taken by some of the ulama, and amongst them he mentioned Omar ibn Khattab and also Ali ibn Abi Talib and others who align to that view. And as for that they mentioned regarding concern of an incident that took place regarding concerning Ta'un, that a plague occurred in Sham, and the plague is Amwas. So the plague of Amwas that occurred in Sham in the time of the Khilafah of Omar al-Khattab, we find that many people died. So they mentioned that Omar in that case that is allowed regarding that people inherit between themselves. As for the first group, they use concerning a matter which is regarding the battles or some of the battles that took place between the Muslim. So he mentioned regarding some of those battles that took place between the Muslim, that they fought each other, that they didn't per se any inheritance that took place between them. But so you have those two views that are there, those two views that are there. Aywa?
According to this opinion, every heir among the dead persons inherits from the original estate of the other dead heir, excluding the new estate. To elaborate, if an heir is assumed to have died earlier than another, the share of the latter gets from the former is to be distributed among latter's live heirs only, i.e., we exclude the former from whom the latter has inherited, and we reverse the assumption and apply the same way of distribution. The first view, indicating that they do not inherit from one another, as no inheritance is to be made without doubt, is the preponderant one.
So Shaykh Fawzan, he mentioned Ar-Raja, meaning concerns that preponderant, that the view that he also be the correct view. So he mentioned both views that are there. They mentioned Ar-Raja في هذه مسألة هو القول الأول. So he's more that a line or the Shaykh takes the first position, that there's no inheritance between them. So in those cases, so these three cases that are mentioned, that there's no inheritance that takes place between those people who have died as together. Aywa?
This is because the actual status of the deceased ones, the heirs, is unknown, and what is unknown is deemed non-existent. Moreover, the precedence of the death of one another is unknown, so it is insignificant in this case. Besides, it is not reasonable to have deceased heirs inherit from one another, as inheritance is made to let the heir make use of the inherited property, which is not the case here. Also, making the deceased persons inherit one another is a contradictory view. This is because giving a deceased heir from the estate of another indicates that the former has survived the latter, and then giving the latter from the estate of the former indicates the opposite. This implies that each of them has died before the other, which is not logical. With this in mind, the preponderant view is that only live heirs inherit the estate of the deceased ones in order to adhere to what is certain and keep away from doubtful matters, and Allah knows best.
Okay, so based upon that, this view that the Shaykh considers to be the more correct view, the first position is based upon their certain ihtimal wa shak, based upon their certain doubts and some matters that are as unclear. So based upon that, the ahkam of Islam should not be based upon things that are not clear and straightforward. So that's concerning that discussion they have regarding of those cases regarding of inheritance. Do people who died together in a mass type of death, do they inherit from each other? And we discussed that they put them into 5 categories, and of the 5 categories, in 4 of those cases there's no inheritance between them, and in 1 case there's inheritance. So in a nutshell, so I mentioned that yes, that's concerning that. So the last that he mentioned that there's a khilaf between the ulama, but the Shaykh of the view that they do not inherit between themselves. As for the other scenario, he mentioned that 1 case, that if they all die together and it is known, and there's no one who precede the other, then they all do not inherit between themselves, then that's an ijma, so that's clear. And the other case that he mentioned, if you are able to make clear distinction as to who died first and came after, and it is clear, then they inherit. But in the other cases where there's some doubts, or the person knew he died but he forgot, so again that it left the person still again in some form of doubt, then in those cases, or the person is ignorant as to who died first and did not, then in those cases, because of that possibility of the unknown, then the Shaykh aligned to the view that they do not inherit. Aywa?
So I can ask a question. It's not related to this, but if I don't ask it now, I'm going to forget. At what age can a young man, a young boy, or a grown-up boy be mahram for his mother?
After puberty.
After puberty.
Then you consider to be? a man.
So as soon as he's showing those signs of puberty, then he can.
He becomes a mahram.
And they can travel any distance.
They become like, at that age, they become like adult.
Yeah.
So I said, even though they might still, in this society, be considered to be underage. For example, a boy, he's 15, as an example, or he's 13, but he's reached the age of puberty. Then he's a mahram. So he can travel with his mom from here to wherever. No?
Yeah, for any reason, no matter what.
So you can fulfill. So at that age, for example, as an example, we'll discuss after the next time, so that he's 13, but he's mature, he has reached the age of maturity. Then he can act even to marry a female in his family. You understand? Because Islamically, he's considered to be a grown adult now. Even though he may be 13, but he's considered to be above the age of puberty. But so that technically, he can carry through those responsibilities.
بسم الله والصلاة والسلام على رسول الله قال مؤلف حفظه الله chapter 21 page number 327 Inheritance by Rad. According to scholars of inheritance, the Rad means giving the remainder of the estate after the prescribed shares are divided to the legal heirs entitled to prescribed shares in case there is no agnatic relatives entitled to get the remainder. Allah exalted be He stated the prescribed shares as half, 1/4, 1/8, 2/3, 1/3, and 1/6, and explained how the agnatic males and females inherit. The Prophet ﷺ also said, "Give the shares of the inheritance prescribed in the Quran to those who are entitled to receive them. Then whatever remains should be given to the closest male relative of the deceased." This noble hadith clarifies the text of the glorious Quran and puts the heirs of both types in the right order. Those entitled to receive prescribed shares, then the agnatic relatives. According to this hadith, whenever both types are involved in a case of inheritance, those entitled to prescribed shares are to be given their due shares first, and then the remainder, if any, is to be given to the agnatic relatives. If there are agnatic relatives only, they are to be given the whole estate divided according to their share. The problem arises when there are persons entitled to prescribed shares whose shares of the estate are less than the amount of the estate, and there are no agnatic relatives to get the remainder. In such a case, the remainder will be distributed among those entitled to prescribed shares in portions to their prescribed shares, except the two spouses, according to the following proofs. First, Allah exalted be He says, "But kindred by blood are nearer to one another regarding inheritance in the decree ordained by Allah." Surah Al-Anfal, Ayat 75. Those entitled to prescribed shares are the deceased's blood relatives, so they are more entitled to the deceased estate than anyone else. Second, the Prophet ﷺ says, "If anyone leaves a property, it goes to his heirs," related by Al-Bukhari and Muslim. According, this rule is general in all types of estate left by the deceased, including what is left over the remainder after distributing the prescribed shares. Thus, one's legal heirs who are entitled to prescribed shares are more entitled to one's estate than anyone else. Third, Sa'ad ibn Abi Waqqas, may Allah be pleased with him, narrated that he said to the Prophet ﷺ while he was visiting him because he was ill, "O Messenger of Allah, I have no heirs except my only daughter." The Prophet ﷺ did not deny restricting the inheritance to the daughter. If it were impermissible, it would not be approved by the Prophet ﷺ. This denotes that the one entitled to a prescribed share gets the remainder of the estate if there are no other agnatic relatives, and this is what is meant by the Rad.
And so Sheikh is discussing this matter regarding that we mentioned those who are said to be a furud were either from the asl, from the side of the parents, or by way of the children that they have received, with the exception of husband and wife. If they have received their portion, which their portion usually fixed, either 6, 8, a third, 2/3, or those prescribed amount, if they have received their portion of the inheritance, but there's still a portion that still remain, and there's no other family members to receive this from those who are inheritors. So those who are the fard, they have received their portion, but then there's still things that remain and not yet been proportioned, and there's no one to receive this. Then then rod, it goes back now to those ones who are the original inheritors. So from the children, or from his parents, or from children, they'll get an additional amount. Clear? So that's the case that they're discussing.
The rad is applicable with regard to the persons entitled to receive prescribed shares except the two spouses, for they may not have a common blood relationship.
And that's why they're exempted, because the others who still receive are the ones who have direct blood relation. As for the husband and wife, that there's no blood ties between them.
Thus the husband and the wife are not included in the general denotion of the following verse, but kindred by blood are nearer to one another regarding inheritance in the decree ordained by Allah. Surah Al-Anfal, Ayat 75. Scholars have unanimously agreed that the two spouses are not among those who are to be given the excess of estate. Yet it was reported that Uthman ibn Affan, may Allah be pleased with him, once judged that the remainder of the estate is to be given to a husband. Scholars view that Uthman's judgment may have been due to a reason other than the rad, such as being an aggrant relative or having a blood relationship with his wife, and Allah knows best.
So you have those cases, so regarding that, they agree regarding those matters, but you find an exception regarding, in one case, that Uthman ibn Affan, that from the Sahaba, Kibar Sahaba, that he made a judgment contrary to what is the established ruling. So what was the reason? The reason behind he made such a ruling in this particular case, that ulama, they give put forth an excuse that it seems as if that the case could be that person that was received, that there were some blood ties that was involved. There were some blood ties that was involved. And it shows regarding concerning the ulama, so it shows that one that matters regarding aqwal of Sahaba, then also those things are looked at carefully. So you find something that general, you find a general hadith, but you find a Sahaba saying one, or some of the Sahaba saying different, then why is this? And also, if the text is very clear, then it's given an excuse as to why they may go against such text. And also that rule applies to the ulama in general. So that rule applies to the ulama in general regarding giving them some form of excuse why they may go against certain texts. So, تفضل. Yeah.
This example, for example, the man married his cousin, so he got his inheritance from being a husband, and then because there was no other agent to take the remainder of the estate, he took it as her cousin. So
They take it as a relative. So not because of, in that case, not as being an husband.
So he got his husband.
He gets husband shares from before, but the other additional excess is because of blood ties, because of, for example, being a cousin.
بسم الله والصلاة والسلام على رسول الله. قال مؤلف رحمه الله, chapter 22, page 331, Inheritance of kindred by blood. According to scholars of inheritance, kindred by blood are the relatives who are not entitled to have prescribed shares, nor are they from one's aggrant relatives. They are four types. First, those who belong to the deceased, namely daughters, children, and the children of the sons, daughters, and so forth, and a descendant lineage. Second, those to whom the deceased belongs, namely the non-inheriting grandfathers and grandmothers, and so forth, in an ascending lineage. Third, those who belong to the parents of the deceased, namely the sisters' children, the brothers' daughters, and the children of maternal half-brothers, and whoever is related to the deceased through them, and so forth, in descending lineage. Fourth, those who belong to the grandfathers and grandmothers of the deceased, namely the deceased's father's maternal half-brothers, all paternal aunts, all female paternal cousins, All maternal uncles and all maternal aunts, no matter how far all these relatives are, and their children, however low in a descending lineage. These are the types of kindred by blood in general. They are to inherit if there is none entitled to inherit prescribed shares except the husband and the wife, provided there are no agnant relatives. This is according to the following evidence. First, Allah exalted be He says, but kindred by blood are nearer to one another regarding inheritance in the decree ordained by Allah. Surah Al-Anfal, Ayat 75. This means that blood relatives are entitled to inherit each other's according to the judgment of Allah. Second, the general implication of the following Quranic verse: for men is a share of what the parents and close relatives leave, and for women is a share of what the parents and close relatives leaves, be it little or much, an obligatory share. Surah An-Nisa, Ayat 7. The words men, women and close relatives include one's kindred by blood. Thus, whoever claims that the verse refers to a certain case should prove his claim. Third, the Prophet ﷺ said, the maternal uncle is the heir of him who has none. Related by Ahmed, Abu Dawood, Ibn Majah and At-Tirmidhi, who deemed it Hasan.
So I mentioned a hadith here that al-khal warith, man la warith la, that this hadith that is in the Ibn Abu Dawood or Ibn Majah or Tirmidhi, that I didn't get a chance to verify this hadith. As I mentioned, قال الترمذي hadith Hasan. So regarding concerning hadith, sometime it is mentioned by Aisal, didn't get a chance to verify the ruling on the hadith. But they mention here, At-Tirmidhi rahimahullah said the hadith is Hasan. Aywa.
This hadith signifies that the maternal uncle becomes a legal heir when there is none entitled to a prescribed share or agnant relatives. As the maternal uncle is from one's kindred blood, then the same rule can be applied to other relatives from one's kindred. These are...
Kindred means what? Ancestry?
Hey, family tie.
Kin,
Family,
yeah,
kin and blood.
These are some proofs supporting the view of that one's kindred by blood may inherit. This view is reported by some of the Prophet's companions, including Omar ibn Khattab and Ali ibn Abu Talib, may Allah be pleased with them. This opinion is adopted by the Hanbali and Hanafi scholars and is one of the two views adopted by the Shafi'i school in case the affairs of the public treasury are not settled or it is not established as a unique institution. The scholars who view that the kindred by blood are to inherit differ regarding the way they receive their share of inheritance, and they have some views, the commonest of which are the following two. First view,
What's the word have there? The common? What's the word have?
Commonist.
Communist. It means ashwaruha qawlan, that the more renowned of the views are two. So ashwar mean the more renowned.
Communist.
Aye. Communist, more well known, more common. Aye.
Yeah, that's what I would have said, but communist is not
Yeah, I
a
would
word.
say communist.
Yeah, that's not a word.
Aye, the more, aye, what?
First view, they kindred by blood are entitled
You're like
to
a
inherit.
cold English man. Was it a Queen English?
No, I think that's New English, that one.
Yeah, it's a bit,
New
yeah.
English, 2024. First view, they kindred by blood are entitled to inherit by considering every one of them in the place of the one to whom she is related to the deceased, i.e., to be given such a person's share. Thus, daughters' children and the children of the sons' daughters are to be treated like their paternal aunts, are to be treated like their mothers. Afwan. Likewise, the deceased father's maternal half-brothers and also paternal aunts are to be treated like the father. Similarly, the maternal uncles, maternal aunts, and maternal grandfathers are to be treated like the deceased's mother. However, brothers' daughters and the daughters of the brothers' sons are to be treated like their fathers and so on. The second view, the kindred by blood are to inherit the same as the agent relatives do, i.e. the closer the relative is, the more she is entitled to inherit, and Allah knows best.
Okay, so that's matter of khilaf between the ulama regarding those who affirm or those who take the view that they should inherit from the relatives. As to how it is proportion, what portion each receive, then also they have a khilaf, a difference between themselves, and he mentioned the views that are there. So those are matters that relates to those additional matters that relates to the bab of fara'id, mawarith, inheritance that are being discussed. Inshallah ta'ala, we'll end here for today. We have enough for maybe one more chapter or for one more lesson. So we end here. As they said, mirat al-mutallaqa, woman who's a divorcee, would that make. So we'll leave that one until the next lesson, inshallah.
Inshallah.
Ikhtilaf fi din. That two more remain, huh? Can we do them now, or think we can do them or leave them?
You could therefore do one of them now.
Or leave them then. We'll leave the both to do them together.
Yeah, we've got 3 chapters.
We have 3, okay. 3 chapters, and also Qatl, Aywa, 3 chapters. Yes, so we'll leave that all inshallah ta'ala for the next lesson, that we'll try to cover through those 3 that are important regarding in case of divorce, in case of differences in religion, in deen, that are upon the different religion, and that is regarding Islam and others, and also between other religion. What's the ruling regarding that cases, and also case regarding al-qatil, regarding someone who have killed another person from the family. Do they inherit, not inherit? So those inshallah ta'ala will discuss in the next lesson. وَبِاللَّهِ تَعَالَى تَوْفِيقٌ وَهَذَا السَّبِيلُ وَالْآخِرَةُ وَالْحَمْدُ لِلَّهِ آمين.
This chapter is heavy. It's a mouthful.
Very heavy.
More than one. Huh?
Yeah.